Part 5. Employment law. There are many laws in existence which relate to the area of employing personnel to work for your organisation. These laws cover such aspects as pay, discrimination, equality, employment rights and responsibilities, contractual terms and conditions, and data protection. The Employment Act 2008. This law reveals mandatory statutory dispute resolution procedures which relate to grievance and dismissal. It removes the regime which rendered the dismissal of an employee automatically unfair. It permits employment tribunals to increase or reduce awards by up to 25% if an employer or an employee unreasonably fails to act in accordance with the ACAS Code of Practice. It does now abolish a set timescale for ACAS conciliation. It allows provision for tribunals to deal with certain claims and issues without a hearing, and it includes sections which deal with new rules on the national minimum wage and changes to trade union law and provisions which apply to employment agencies. So this is quite detailed. Another law that relates to this area is the Employment Relations Act 2004. This is mainly concerned with collective labour law and trade union rights. Then there is the Work and Families Act 2006. This includes 52 weeks statutory maternity leave for all working mothers regardless of length of service, extension of the period of statutory maternity pay from 26 weeks to 39 weeks, arrangements for employees and employers to keep in touch during the leave period, the employee being required to give 8 weeks notice if intending to return to work prior to the end of the maternity leave period, the partner, to be able to take additional paid paternity leave of up to 26 weeks currently if the mother returns to work without using up her full entitlement to paid maternity leave, and the right of workers to request flexible working hours if also caring for adult relatives, so not fixed hours of 9 in the morning to 5 in the afternoon, for example, but working the necessary full hours per week or per month, but being flexible as to the hours that they do that fits in with other activities. Another law relating to this area is the Employment Rights Act 1966. This covers a written contract of employment, including the main terms and conditions of employment. All people employed should be in receipt of a contract from the company. This must be provided to the employee within 2 months of their starting work for that organisation. The elements of this contract would include such things as a statement of employment particulars, including a pay statement, how much they're to be paid per week, probably per month, protection of their wages, protection from suffering detriment in their employment, in their role being employed in the company, and time off from work for such duties as public duties, to look for work and training or retraining if they're in a redundancy situation, antenatal care, which might be leading up to giving birth for a lady, and employee representative meetings. Also suspension from work on medical grounds or maternity grounds, maternity rights, termination of employment, notice periods, written reasons for dismissal, and that the employee must not be unfairly dismissed. Also any redundancy provisions and payments. They should all be included in the contract, the written contract supplied to the employee within 2 months of them joining a new company. There are also a number of laws or acts concerning discrimination. One is the Sex Discrimination Act from 1995 onwards, the Race Relations Acts from 1976, but also 2003, the Disability Discriminations Act, again 2 of them, 1995 and 2003, the Equality Act 2010. All of these exist for one particular purpose, to protect workers and potential workers in the work environment. They exist to protect people when they are applying for a job, as well as protecting them once they are in the workplace. They are simply based upon the right to have an equal opportunity, and this is irrespective of gender, race, ethnic background, colour of skin, religious beliefs, disability, and other aspects and elements as well. They should be allowed to apply for a job, to obtain that job, and be treated respectfully and within the law and fairly in comparison to all other workers once they are operating within the workplace. There is also a national minimum wage law, began in 1999, so within the UK, that came in by the Labour government. It came into being to prevent employers paying unduly low rates of pay to their employees. It does also help to create what's called a level playing field for employers when they are recruiting staff. The rates of pay will depend upon the person's age group, the type of work that they're expected to do for the organisation, and these rates of pay are normally calculated on an hourly rate basis. I'll give you examples. These examples are in fact due to come in from October 2011 in the UK. The first of these relates to the age group generally, because this is actually the apprentice rate, so an apprentice can be of any given age. That apprentice rate is a minimum rate now of £2.60 per hour, as I say, from October 2011. For others who are not going to be employed simply as apprentices on a training scheme, it will depend purely upon age. So for those aged between 16 and 17, they will be paid a minimum of £3.68 per hour. Those aged between 18 and 20 to be paid at a rate of £4.98 per hour as a minimum. And for those aged 21 and above, a minimum payment of £6.08 per hour. There is also the European Working Time Regulations, 1998. This covers daily working hours, rest breaks, holiday entitlement, and applies to workers and employees who are working under contract. These are not full-time employees as such, those who have agreed to work for a company for a given time period. And finally, the last one I'll mention in this introduction is the one referred to as the Data Protection Act, 1998. This is the second of those laws. The other one earlier had to be updated. And it is concerned with personal information. It gives greater rights of access and limits the information that may be collected. It applies to personal data which may be held on computer, manually, or in any other format, and is in a system that is readily accessible. It covers all aspects of the processing of data, from its collection, its holding, its access, its use and disclosure. And organisations must register what is being held and the reasons and relevance of that information that's being held to their particular business. I trust that the content which has been covered in this introduction to English business law has been both interesting to you and relevant to you. Clearly, it would have been particularly relevant if you are considering an opportunity to set up your own business, because that will help you to overcome some of the so-called stumbling blocks in doing so. Thank you very much for watching and listening.